all of those things. Okay, so we will get our the recording has just started, so we can proceed this evening. Right, so when we left last week, we finished, or rather we did a little bit of Regulation 68, and we also just touched on Section 45(1), which were these estates and the deaths, because we were still busy with the estates, and we also had to finish and do more work on Regulation 68. Right, so what we will be doing today is we will just finish up with the Regulation 68 applications. There were a few questions that came up. I think it was Yanni that asked a specific question. I just want to see if I can bring it up on my other screen. Then I can just go through it. Because it's quite it was a good question, and I must say this week has been really hectic. I think I still have to answer people that asked me a question last Friday, and they are waiting for me, or consultations I had on Friday last week. I still haven't gotten to answering back, but yeah, this is the hectic part of everything. Okay, so on my other computer, I'm just opening the emails, and then I think it was Yanni that Yanni Boita. Yeah. Okay, so Yanni asked this question. She said, with regard to Regulation 68(11)(b) and 11(c) of the DRA. Where both the client and the deeds office copy of the bond is lost or destroyed, and it is not the intention of the parties to cancel the bond. So in other words, they don't want to cancel the bond; they just want copies of the bond. It would seem. Okay. So the question is, it is suggested that the procedure under Regulation 68(11)(b) and 11(c) should still be followed by cancelling the bond. You can then either register a new bond, RCR 22 of 2016, or the court may be approached for the appropriate order. That's Registrar Conference Ruling 7 of 2018. So the first thing I would like to ask Yanni is just it says it's lost, both the copy of the deeds office copy of the bond and the client is lost or destroyed. Okay, and they don't want to cancel the bond. So the first thing is we are not going. The first thing we have to understand is the following: when we have a situation where both the deeds office and the client's copy has been lost, then you can't go the Regulation 68 route. You can't. This is now a situation where you go for a certificate of registered title. Okay, so you have to apply for the certificate of registered title in terms of the regulations, in terms of the section, sorry. So specifically, the regulations that allows for a lost deed that has been lost by both the client and by the deeds office. You cannot bring a Regulation 68. Yes, you follow the same procedure. Okay, yes, you follow the same procedure in your affidavits that you bring the application with. Okay, yes, that you do. So you follow the same sequence of allegations that I went through the last time, where we said you've got to say is I'm the owner, the deed or the mortgage deed is lost. It got lost under circumstances unknown to me. It hasn't been pledged, or in this case, obviously there's a bank involved here. it has been pledged, but it hasn't been pledged to anyone other than that specific bond. Okay, and then obviously you're also going to state there that if this deed comes to hand, it will be handed handed in at the registrar's applicable office. So the first thing here is no, you can't apply Regulation 68 at all. You can only apply Regulation 68 in those circumstances where only the client's copy has been lost. But if the deeds office copy and the client's copy is lost, then we go for a certificate of registered title. Remember what I said to you just in closing last week, or not last week, it feels like last week, but at our last lecture, I said to you, a certificate of registered title is also known as a substitutive title. That means it goes and it stands in the place and stead of the title deed. So, and because of that, I take out a certificate of registered title. Yes, that's correct. Section 38, not Regulation 38. It's section 38, and I'm going to, when just a little bit later, I'm going to give you the 10 certificates of registered title. I'm not going to go into a lot of depth into certificates of registered title. I'm just going to give you a simplified way of how to remember certificates of registered title. Okay, I will upload additional information to eLeader, but Mike will be lecturing this. He said to me on Saturday he will do some bonds and he'll do CRTs. So what I am going to do is I'm just going to assist you with the basics, basic CRTs, and then he's going to go the route of section 40, the consolidations, and section 43. Remember I said to you those two are the most important. You will get one of them. Well, I can almost guarantee you that you will get either a section 40 consolidation, CCT, or you will get a CRT under section 43, which is those subdivisions. And remember, when we did our conditions of title, also the last time we had the lecture, we did the conditions of title. Now that is exactly how we apply them when we are dealing with a subdivision. So that's how we qualify our different conditions in those situations. So very important to always ask the question for yourself, whose document is lost? Is it only the client's, or is it the deeds office copy and the client's? Because only if it's the deeds office copy as well that's lost, that is when I go the section 38 route. But I cannot use Regulation 68 if the deeds office copy is still available. So never can you ever apply that specific Regulation 68 if the deeds office copy is also lost. Okay, so I think that explains that question. I see that the question was further that which is more cost effective, to register a new bond or apply for to court. You don't need to register a new bond at all. You don't need to register it. Okay, so I'll post additional information to make it easier for you to remember this. Remember that Regulation 68, client's copy. Section 38, deeds office and client's copies are gone. That's why we bring the same affidavits to say, I don't have a copy as the owner, and the deeds office copy is now also lost. So then we compile it from, we reconstruct the title deed from the parent and the holding deeds that has the record. And as I said to you as well, as and if all else fails, then I have to go the route of looking at my flyleaf when my township was established. Okay, so always remember the difference between those, and also remember Regulation 68. When I want to cancel the bond simultaneously with the transfer, there's a specific registrar circular. It just escapes me at the moment, that says you don't have to advertise. you don't have to advertise and to have a copy issued when your mortgage, this is now only for the mortgage bonds, where your mortgage bonds are lost, and you now need to cancel it simultaneously with the transfer. Then you don't go that long route of advertisements. That advertisement has its prescribed form. It's form JJJ. I've just recently done one, so I've got the advertisement and everything that I'm going to upload so that you can see what the advert looks like, as well as what the affidavit and the form JJJ looks like. Okay, so you'll have a perfect example there of Regulation 68 situation, but always just keep the two apart. The two must be kept completely apart from each other. Okay, Regulation 68, client's copy is lost. Section 38, deeds office copy is lost. Okay, right. So so just as I said, we basically just did a little bit of work with the Regulation 68, but I've explained to you is always remember those subsections. You should go through the whole of the Regulation 68. Okay, you should know each and every one of the situations, the ones that you deal with most of the time, and also that you need to specifically prepare for the exams, is 68.1, Regulation 68.1, Regulation 68.2, that is the consent by the bank to issue. Then we have Regulation 68.8, which is that unserviceable, remember the Mareike one, where I wrote on the title deed thinking I was writing on the draft deed. Okay, and then we have the share of transfers Regulation 68, sub-regulation 14. But also remember, now I have my situation where my bond has been lost as well. Okay, so just summarize those for yourself. On the e-leader, there will be an example of each one of the applications and also how to deal with them. Okay. So all of that will be there. I don't really think that we have to say much more than that. It's a basic application, which is only going to say prep clause, application in terms of Regulation 68. I, the undersigned, I'm the owner, and we've gone through this before. What do I want? I want a Regulation 68 to be a copy to be issued by the registrar, and I have to adhere to those requirements as per the Act. The nice thing is if you go into your drafting exam, you're going to have the Act, the regulations, and the forms with you. You're not going to have them if you go into the short paper, which is the 1 for 100 marks, which is law. Okay, you're not going there. You've got to know everything off by heart. That's why I hammer on the law so much. I think you guys may feel that you want to puke already, because I keep on going on about the law. Trust me, this is extremely important. You have to concentrate on that. I have to just say, in passing, I figured out how to use hotspot. So if we have a future problem with power, now I've figured out that I can use hotspot because my own Wi-Fi is off if the power goes down. Okay, so I'm sure that question from Yanni was now answered. If it's not, then Yanni, just pop me again an email to say to me, give me more details, and then I can look into it for you further. To me, I just think the basic error might be that you confused Regulation 68 with Section 38. Okay. So,
sorry, Mareike.
Yes.
Just to interrupt one moment. Sorry, colleagues. I just wanted to inquire. Perhaps I'm incorrect, but when I'm looking at Section 38, it reads if the title deed has been lost. Yes. Now, the mortgage bond is not a title deed. So how can I apply Section...
Okay, it's a deed. By
Okay, so it
implication,
falls under it.
yes, by implication,
Okay.
it falls under it.
Okay.
Because if you look at any deed, mortgage deed, notarial deed, you name it, that is what we refer to when there is a deed lost. Okay, so if that is the case, then we take the route there. And if it's lost in the deeds office, then by the deeds office, they don't have their copy either. We go the regulations 38. It's actually a good question that you asked. I just assume that everybody understands that a deed includes a mortgage deed, etc., etc. So it's good to point that out. It's certainly something that I'll concentrate in future on to make that clear. Okay. Thank you, Yanni. I appreciate that question. Just want to see if there's other things that I've missed yet. I've got such a sensitive mouse on the laptop. Manish, do you have a question? I acknowledge you. I see your hands up.
Yes, Marika. So the mortgage bond is generally held by the bank, right?
Yes.
So what are the chances of it getting lost?
They lose them, eh?
Is it?
They literally lose them. They do lose their own their documents, whether it's the deed or the bond. They tend to lose them. It's just it takes so much longer.
I just want to get something clear. So if the bank loses the mortgage bond and you need a copy of it, I still don't understand why would you need a copy of it.
When Yanni says the client, then I would assume she's on the panel of or her firm is on one of the panels of the BCs, the bond cancellation.
Bond cancellation attorney.
Yes, the bond cancellation panels with one of the banks, and in light of that, her client, the bank, is now looking for that deed, for instance. But remember also,
yes.
Just remember also that a bond is not always just a bank's mortgage. It could also be an asset in my estate. So that means I could have advanced money, and I said to, for instance, my family member, I'll give you the 500,000 rand, but I need you to register a bond in my favor over your property. Then it's an asset in my estate. So if it's then lost, then I'm the client and I may want to have a copy of that deed, the bond deed, the mortgage deed. Maybe because I'm sorting out my filing. Maybe I want to do a will and I need to clarify the terms in terms of the bond, etc., etc. So either the bank or it could be a client in the sense of it's a personal bond that was registered. So when I say personal, I basically say you stepped into the shoes of a bank. That makes sense?
It makes sense. Yeah.
Yeah. Okay. I think we just tend to sometimes just look at bonds, etc., from the point of view, banks. But it isn't just banks, and that's why bonds are so important to understand properly. Because when you do bonds, you have to understand that there's something called a kustingsbrief, which is now exactly that situation where, for instance, the seller of a property advances a portion of the purchase price. But he wants, while he's selling the property, he also wants a bond to be registered in his name. That's a kustingsbrief. Okay, there is no English word for a kustingsbrief. And when bonds are done, by Mike, I'm sure he will explain kustingsbriewe as well. Okay, so kustingsbriewe, I always explain like a kus, like a kies. So my seller and my purchaser are basically joined to each other in the sense of I'm selling my property to you, but you're going to pay me by way of a bond, so that there's security. There's security that is given for that registration. Okay. Does that answer all the questions? Okay. Right. So.
Yes,
okay, thank you. So something else, I've been seeing it come up because I'm going through exam papers in order to assist you with those of you who are doing mentorship sessions. Something that I haven't spent is regulation. Regulation 51. Okay, so and I want us to quickly just look at it. There is a regulation 51. As I said to you initially, I said to you, whenever you are told or asked, list the documents that are lodged, you will always go that easy route that I said to you before. Lodge all the
Marika, can you hear me? Marika? Marika? We've lost you.
Marika.
I'm not quite sure why. Can everybody hear me? If somebody can just give
Now
me
we can. Now we can.
Marika,
Now
we couldn't
Yes.
hear you. Were breaking up.
Oh, okay. Okay. Sorry. Okay. I think it's the mouse that was a bit of a problem. So guys, I think I'm just trying to figure out where you guys where I lost you. I just want to quickly see here. Okay, so regulation 58. Okay, well, it's not regulation 58. Okay, I'm thinking that it's regulation 51 that I was starting to discuss. Thanks, Fred. I think that's regulation 51 that I was discussing, right? With regards to the list, the number of documents that has to be lodged, or rather the original deed. When do I have to lodge the original deed? Which is, as I said to you, as a general rule, I'll always have those 5 things, which includes my holding deed. But regulation 51 gives us exceptions to that rule. Okay, so there's exceptions to it, and if you please mark it in your book, because the reason why I'm bringing that up now is because of regulation 68. And over and above that, it ties in with your sheriff as well. The sheriff is always going to be an exception. The sheriff, if it's a sheriff transfer, I don't need to worry about lodging the deed, as long as the sheriff can say, I did a diligent search and I can't find it. Then that would be it. That would be the end of it. So if you look at regulation 51, just quickly to read it to you, where it is sought to deal with immovable property, the title deed of such property shall, save as provided in the Act and in sub-regulations hereof, be produced and be mentioned in the deed dealing with such property. So general rule, I will lodge my deed. Okay. And then it goes on and it says, it shall, however, remember always that general rule, the golden rule, and then we come back and we qualify it. That's how most things in conveyancing works. So it shall, however, not be necessary unless the registrar so requires to produce any deed by which the property was previously held, whether such deed be the diagram deed. When we talk about the diagram, that is now when we do a subdivision, but also we refer to the diagram deed also as the mother deed or the holding deed. Okay, so you can basically, let's say, group those concepts together. We will, when we do township establishment under CRTs, we revisit those concepts. So you will lodge the deed unless the registrar says it's not necessary. Okay, and under those circumstances, there would be an endorsement to this effect. Now, if we look at 51 subsection 2, it basically says the cession in execution. So where immovable property is to be transferred or ceded in execution of the judgment of any competent court by the officer appointed by law or by such court, or where such immovable property is to be transferred or ceded by an officer appointed in terms of a law pertaining to insolvency. So there's my second exception. The first one is judgment, and judgment is done by the sheriff, okay, or executed by the sheriff, right? The second one is if I have an insolvency. If there's an insolvency, so in other words, my executor, not my executor, my trustee in the insolvent estate, right? So under those circumstances, officer appointed by the court or insolvency, or by an executor referred to in section 56, subsection 1, subsection B, it shall not be necessary for the property for the deed of that property to be lodged as long as the executor or the court-appointed person can certify in writing that he or she is unable to obtain possession of such a deed. So please go and have a look at section regulation 51 and 50 sub-regulation 2. Okay, right. So those those exceptions to when do I not have to lodge my holding deed. Those always come up in the exams. For some reason, it's a quick 4 marks that they ask, or 5 marks, depending on the allocation of marks. Okay, so please, that's why right from the start I say to you, there's my rule of 5, but there's always exceptions to that. And that holding deed, I don't have to lodge in certain circumstances, such as I've said, liquidator, trustee in an insolvent estate, in the case of a transfer by court order, so in other words, the sheriff transfer, and then you can just go on and look at all the other situations. And interestingly enough, in this section, it says, and it goes on to refer to section 38. Okay, so if you just read on, if as long as you can certify, or the person can certify that he's done, you know, he's unable to obtain possession of that title deed, then you can that would be sufficient, and you wouldn't be required to lodge the original deed. But then there's a provision, like in everything in conveyancing. And that is, if you just read on, it says, provided that where the duplicate original of such title deed filed of record in a deeds registry has been lost or destroyed, it shall be necessary for such officer or executor to obtain a certificate of registered title. Now, see, that's what I referred to when I spoke to, or when I told Yanni that you've got to go the section 38 route. Okay, but you will never forget section 38 now ever again, because I've told you it's a CRT. It's a CRT. And I can't, why? Because in this section as well, it says the deed at the deeds office is also lost. The duplicate original at the deeds office is also lost. Okay, then I go the route of section 38. Okay, Right, so just read what it says there. If it's it shall not be. If it's lost, it shall not be necessary for such officer or executor to obtain a certificate of registered title under provision of Section 38 of the Act, for which purposes such officer or executor shall be regarded as the owner of the immovable property. Provided further that the case of in the case of transfer of immovable property by virtue of a second provision, which is Section 16. Okay, which one is Section 16? Section 16 is the government obtains all the land. It's an endorsement. We did endorsements, remember? My application in terms of Section 16. Government receives all the land under the specific title. So that's one of those exceptions as well. Please read this section. Even though there is in the notes a brief summary of that, just tie it in with what we are doing now, because we are now working with Regulation 68 and the lost deeds. Okay, but now remember, I don't have to always lodge my original, and I don't have to always bring an application in terms of Regulation 68 or even Section 38, depending on the situation. Just remember that Section 38 is the one where everybody lost their copy, including the deeds office. Okay, then I go the route of a certificate of registered title. Why? I've said it before, substitutes the title. It goes and stand in the place instead of the title deed. Okay, right. So hopefully by the time you get to the exams, you are going to hear my voice in your heads repeating and repeating and repeating and repeating this. Okay, so we basically left off with Section 45. Okay, remember Section 45, and I said to you, we've got all those. I must just look at which one of the mouses I'm touching, because otherwise I'm going to mute you again one way or the other. It's a finicky mouse of mine. So the important part that we now have to come back to at the end of the day is the rest of Section 45. Remember 45 subsection 1, asset in a joint estate. Okay, asset in a joint estate, and therefore I bring my Section 45. Okay, now always remember, as I said to you before, think about Section 21, put it at the back of your mind, those exceptions, my exceptions, 5 exceptions when I don't have to join the executor with the surviving spouse, okay, in the application. Okay, so obviously very important, can't emphasize it enough. You have to look at those Section 21 exceptions. Now, again, I'm going to say is you can't leave this aside. You can't leave this aside because in that first paper, which is the something's happening with the connection, it would seem. Okay, there it's back. In that the paper on the law, you don't get the act, so you need to know sections Section 21 off by heart, as well as Section 45, subsection 1. Okay, and remember those different situations that I've said to you before as well is under Section 45, subsection 1, we also have the RCMA, the Recognition of Customary Marriages Act, and they all of these newly, let's say, equalized kinds of marriages, they all fall under Section 45, okay, because they've been equalized in the in law, in that now we all have the same criteria as to when we are married in community of property and when we are married out of community of property. Section 45 can only be brought in a matter of Okay, so Section 57 only in those situations that are not marriages in community of property, because otherwise I am going to use Section 45, subsection 1. Okay, just remember that if Section 45 applies under the Deeds Registry Act, then Section 21 is not going to apply. Xavier, let me see what that question is.
Yeah, sorry, Marika, we didn't hear you for a short while.
There was a, I don't know, it kept on saying there's a connection error. I don't know why that is, because we don't have load shedding or anything like that. So it seems to be some connection issue. I don't know why. Okay, it seems you lost me somewhere with Section 45. Remember, I said Section 45 is always going to be a person who died, 45(1). Somebody died, but it's a marriage in community of property. It is an asset that I'm dealing with that is part of the joint estate. That's the important part that you have to remember. Section 45, subsection 1, I'm going to be dealing with an asset in a joint estate. And because that is, it's an asset in the joint estate, and the parties, one of the parties have died, okay? Under those circumstances, that is my route for 45. I can bring an application to endorse the deed, or I can do a formal transfer. Okay, right. So I think that is clear enough. I've stressed that enough. But also remember, I can never bring, well, not that's Section 45 in itself. When I deal with Section 45, I will use the citations and the description and the methodology of the Deeds Registry Act in Section 45 subsection 1, and then under those circumstances, it's because it's an asset in the joint estate, I'm not going to follow the route or apply Section 21, okay, which has the rule that says, and I can't say this enough, that says join my executor and my surviving spouse, unless in my different exceptions to that to the citation of the parties. Okay. Now, if you have, you would have received from me that application that I sent you for an application in terms of Section 45, subsection 1. And I sent you the Section 42 certificate by the executor. And in the last lecture, Xavier specifically kept saying is you have to remember that sometimes you are going to be dealing with an executor, which is someone else than you. And in that specific situation, that was exactly why I gave you that Section 45 as an example, because the executor was an accountant. Okay, so again, why do I use section? Why do I cite my parties as I do? Because it doesn't fall within the ambit of any of the exceptions to Section 21 in my citations, read together with Section 45. Okay, so always remember that under those, with Section 45, subsection 1, where somebody has died, this is now the situation where the surviving spouse receives the half share of the deceased person. Okay, and because of that, there is then the application brought in terms of Section 45. Okay, so it's brought by the surviving spouse and the executor. Okay, right. Who brings that application? Executor and the surviving spouse. Okay. Now, just as a side note again, in your notes, page 173, I want you to just write there where it says Section 45 of the DRA. Just write there Bonds, just write bonds. If I need to deal with these parties because one of the persons died, I am not going to use form MM, I'm going to use form T for Tom. Okay, and that is in terms of section 45, subsection 2, subsection C. Okay, this is important for your forms. Which forms should I be able to draw? And how do I use them? Because if you look at those forms, if you look at form MM and if you look at form T, the whole form looks like it's only one paragraph long. But that's not how we actually use them in practice. We literally pull it apart and insert, because that form MM we can use for a cancellation, a substitution. We can use it for the noting of a part payment, a cession of a mortgage bond, all those kinds of things we use it for. So for each and every one of those situations, we have to know which form do I use and how do I adapt it. As I said to you before, if you are really stuck and you are having a moment in the exam, if you had to guess anything, even in notarial practice, if you have to guess anything, guess form MM, because you can literally I'll answer that. You can literally write a whole doctorate, I believe, on just the uses of form MM from a conveyancing perspective. I said that on page 173, where it says section 45, subsection 1 of the DRA. I said just right there, bonds. If I have to deal with the bond, in terms of a section 45(1) application, I have to insert, or I have to make a note there that says I use form T if I have to substitute the surviving spouse under the bond in the name and place of the deceased. Because remember now, on the bond, I would have both parties' names, but now one has died. So the only way I can deal with that is now to deal with it in terms of section 45, subsection 2, subsection C. Okay, C. Okay, you can just remember it in your head as C, cancellation, or substituting that data. Okay, so C. Then I have to use form T, okay, for Tom. Okay, so this really, in my opinion, is money for jam. If you get to the exam, you get this kind of application to draw, you should really fly through it. Okay, right. If you are sitting in the exam and you are having one of those moments, just page through your act. Okay, and then just find if you are having a moment where you just can't get yourself to start writing, or you're just having a freak out moment, which is going to happen, then just page through the act and just go and look. There are formats that you can mark for yourself that says this is how an application looks. So I can literally use that form to just get me in the habit or just in the process of starting to write. But whatever I do in any event, I'm going to start with a prep clause. So if anything else, you start immediately on your page and you write your prep clause down, and then you can calm. If you calm down, you can look at your documents, what you are supposed to be preparing. So specifically there, as I said, start with what you know. Start with prep clause. Okay, I see we are already at 20 past 6. So I have to give us all just more frequent breaks. So we're going to break now until 6:30. Okay, and then we will continue on with the section 45s, and we're going to finish all the section 45s and the estates as far as we can tonight, and then on Friday evening we will finish sundries and also specifically help you with CRTs, because that could be that normally is something that everybody battles with. Okay, so we'll be back at 6:30. Just see if there's any questions. No questions. Let's just be careful of what I touch here. That's my chat. Okay, we are back. Okay, guys, just to quickly put what we are doing in context, I'm summarizing your different sections for section 45, and then we go back to our formal lecture structure on the deceased estates. Just for the moment, we are just taking a moment to look at the 45s. We're going to 45 bis now, and what would be helpful is if you just create a table and write section 45.1, 45 bis 1A, etc. as we go through them, and just make a little bit of a note regarding what I'm saying. There will be a table that sets it out as well, published on e-leader, so it will be there, but just for purposes of you taking notes. Okay, so section 45, as we said, 45.1, that's the deceased in a joint estate. So in other words, parties that are married in community of property. Okay, and now that person has died, so now we are bringing an application. Okay, and this is always the situation where the surviving spouse receives the half share. And I said to you, remember also, it's form T, not form MM on the bond. Okay, so what do we lodge at the deeds office? We do the application, we do the deed of the land or the real right that has to be endorsed. Okay, the transfer duty exemption, because a 45.1 would be an exemption because it's an estate. The rates clearance certificate. Okay, we always lodge the when we're dealing with estates, we lodge a master certified copy and accepted copy. So in other words, the stamp on the will say accepted by the master, and it's certified by the master as a true copy of the original. And then we will do a section 42 subsection 1. 42 subsection 1 as certificate. We don't literally deal with it as such. As I say, we just prepare it. If we are not the actual executor, we make sure that we see the L&D, that it's been published, and that the certificate by the court says that it has lain for inspection and there's been no objections. So if we are not the executor, we have to make sure that we get that information. Otherwise, I can't issue a certificate as a conveyancer in terms of section 42, subsection 1. Okay, that's the one that you have an example for on the Duplessis estate, which was the section 45 that I sent you. Okay, so my 42 subsection 1, I have to, as the conveyancer, be able to say it's lain for inspection, there's no objections, there was no objections, and that it is now being transferred in accordance with the liquidation and distribution account, which has lain open for inspection. Right, what goes with the section 45.1? If there's bonds, as I said to you, my form T, unless I can, the surviving spouse is in a position to settle the bond, then I would cancel the bond, and then, as I said, but if we are going to do a substitution, then it's form T. Otherwise, we lodge the bonds and we lodge the consents by the different banks to cancel. If there's more than one bank, the consent to cancel the bond would be lodged by, together. Okay, so now 45, we've basically summarized what do we have to do and what do we need when we are dealing with anything that is related to section 45, subsection 1, our deceased party. Okay, now we have to remember is what we have to remember is that it's only the 45 subsection 1 where there's somebody that's died. Okay, it's the only situation where somebody has died. The moment we continue on to the 45 business, then we have to remember nobody died. Okay, so nobody died. So my 45 bis 1 small a. Remember I said to you, remember the small a is, it's an asset still in the joint estate, but what happens here is one party acquires the whole property. So in other words, as I said to you, and how I explained it was, I went to court, I made you small, that's why it's a small a. Okay, under that situation, I now, as a surviving spouse, has received your half share, okay, by way of a settlement agreement or a court order, depending on the situation. It is I receive the spouse, the other party's half share. Okay, so with 45 bis small a. As I said to you before, this is our divorces. Okay, this is our divorces. Now, if section 45 subsection A, 45 bis subsection 1 subsection small a, okay, if this is the situation where I acquire the former spouse's property, okay, then the same rules apply here if I want to substitute the debtor, because again, if my name is not on the title deed, I can't be bound by the bond. In order to be bound by a bond, my name has to be on the title deed. Okay, so here again we will use Form T. Okay, because it's again a substitution of the spouses, okay, of one of the spouses. So exactly the same things that we lodge as with our 45, except we don't lodge the will, okay, because there's no death, and furthermore we also don't lodge the section 42(1) because there is no death. Okay. So just my application, all my deeds that are affected or bonds, my court order, obviously, because this is my divorce, okay? My court order, my transfer duty, remember divorces are also exempt, so it's a TDE, not a TDR, a transfer duty exemption. My rates clearance certificate, and there's an exception to this, but also remember the RCC, and then my consents are Form MM, but my substitution, if I have to replace the mortgagors under the bond, then I use Form T instead of Form MM. Okay, then I literally use for my consents from the bank, I use Form MM. This will make more sense when you get to your bonds. Just make sure that at the moment you know which documents you need for practice, for preparation of all of this. Okay. Also remember that you will have to cite the value of the property, and then if you are transferring the half share, then you would also have to state the half share at its value. Because at the end of the day, SARS requires valuation, and also the deeds office for the half share needs to estimate what the levies, the deeds office fees are. Okay, I'll get to you right now, Xavier. So with my deeds office levies or fees, it also just there was a notice just in this week, I think, the levies has increased again. Okay, so yeah, Xavier, there's a question. Is there something I can help?
Yes, please, Marika. Thank you very much. Apologies, colleagues. With regards to the value, is it the entire property's value, or is it only the value of the share?
You are transferring only the value of the share, but when I prepare my applications, I always say the whole of the property's value is this, and we are transferring the half share, which is then the specific half share value. You can, and I have had situations where I refer to the whole value and not to the half share value, and just state that I'm only transferring the half share in into the property. The thing is that your transfer duty receipt has to have then the value that you are referring to in your application on it. So it's for the SARS purposes that we differentiate between the two. But remember also, Section 45 doesn't have a prescribed form, so you can do it the way that I like to do it, to say, this is the value of the property, the whole of the property is valued at this, and we are applying to the registrar for endorsement to the effect that half share to the value of X is being transferred, or in the title deeds are endorsed to the effect that the party is capable of dealing with it as if they acquired the whole property.
Indeed, because that when you do the description of the property, and it also finds its use. I know we've just stepped off 45.2, but your 42 certificate out of your LND, the LND does not have the full value. It only has that one portion.
Yes.
And when you do draft to 42.2, to actually address it with the executor, because there are executors out there that are attorneys, that puts the full value into the estate and into the estate, because their fees are calculated as a percentage of the total gross value of the estate.
Yes.
And as I said, I've seen it before where I said, no, the value of the deceased estate needs to be reduced because it's not the full value of the property. It's only the value of the share.
That's correct.
And they decided not to go Section 21, especially 21D, because the will made it possible for the surviving spouse, married in communal property, to get that share. And they decided not to go 21.1, they went 45.1.
Yeah.
And yes, they described the full value of the property. So no, the full value is not the share, it's only the half.
Yeah, only the half. That's why I said is, I personally, I refer to the whole of the property, but then I specifically state that I'm only dealing with the half share, and I cite that value. Okay. So, but that it's again, these applications don't. Pleasure. These applications don't have a prescribed form at all. So it's up to you. How do you want to draft it? As long as you have the requirement. What is the requirement? You've got to say why this person is receiving it. So it's in terms of a divorce settlement, and then you are going to say, or if it's a 45.1, you would say it's clearly because of the death of the one party. So and you have to ask the registrar to endorse the title deed to the effect as if though you have formally taken transfer of the 1/2 share. Okay, so that's all basically that you need to ask the registrar for. The rest of your form just has to comply with what is a property's description, what is the citation of the parties. That's what it's about. That's where you make up your marks, and obviously just that quick explanation is why did the person get this. Now, it's very important for you guys to understand the difference between Section 21 as opposed to the 45s. And why do we say that the one excludes the other? In other words, if Section 21 apply, then I can't go the 45 route. Okay. And it's all about those 5 exceptions. Under Section 21, it says you always join the parties, right? You'll always join the executor and the surviving spouse, right? But then there's 5 exceptions. There's 5 exceptions, and the first one is obviously my first situation is the half share of the deceased. I'm dealing with the half share of the deceased. But what if I am able to my exceptions here lie under the possibility of I can sell the property to settle debt. Okay, so I can sell the property for debt. That's one of my exceptions. Massing and adiation. Okay. Then obviously also your surviving spouse who is the executor, because under those circumstances, if the surviving spouse is the executor, clearly you can't join them together. Okay, so just look at your exceptions and abbreviate and explain them quickly or summarize them for yourself at the end of the day. Okay, and then pull apart section 42 subsection 1, that's a conveyancer certificate. It's going to the heirs. Section 42 subsection 2, that is the master stamps on my power of attorney, an endorsement that says, okay, you can proceed to transfer. Okay, so it's a stamp after you have completed the JM33 that you lodge at the master. Okay, so 45 bis, as I said, the one is that divorce. We've dealt with that, the small a. Okay, it's a small a. Then 45 bis 1b. Now remember, A is the one where I had a divorce, but now 45 bis 1 small b. This is those matrimonial property changes. Okay, so this is now when I've approached the court and there is a matrimonial property system change. Okay, so and then I have to look at the Matrimonial Property Act, the MPA, for purposes of my method of dealing with the application. So my 45 bis 1 small b is going to be my section 21. Okay, that's my section 21. Okay, section 21, change of the matrimonial property from say in community of property to out of community of property. Okay, so the spouse acquiring the property is then by virtue of the application that was brought. In this situation, I have to I have to be dealing again with initially an asset that was part of the joint estate. After I've gone to court, it now has the effect that the party now, one of the parties now receives the half share of the other spouse. Okay, so we start off with joint ownership, and then one of the spouses are awarded their half share. Okay, but they are still married. Small a is divorce. Small b is still married, not a divorce. Okay, not a divorce. Okay, so there again, I also have to lodge my normal documents plus my court order. Okay, this is one of the situations where you have to actually prove the marriage in community of property. Okay, so that you would have to do, because it's not a death. Okay, you don't use the marriage the affidavit for purposes of the master. You don't use that. Okay, you literally lodge with the registrar proof of the fact that you were married in community of property. Okay, and that is your marriage certificate accompanied with an affidavit. Right, so here again, my transfer duty payable on a half share, because I didn't have the half share. I had a half share, undivided half share into a property, because it's 100% in the joint estate. But now, by that order that happens, when that order is granted, now suddenly I actually acquire that half share. So there again, I have to, even though it's calculated on the half of the value of the property, So in other words, if it's 800,000, it would be 400,000 that the transfer duty is calculated on. I have to lodge that transfer duty receipt. Okay, so who brings this application? The spouse that's getting the property. Okay, so you don't need the assistance of the other person. The spouse that went to court and was awarded the property now, by virtue of the change of in community of property to out of community of property, that spouse brings that application via themselves. Okay, right. With that 45 bis 1 small a, where it's a divorce, exactly the same. Whoever has awarded the property, okay, that person brings the application. You don't have to get the signature of the spouse. You don't have to do that. Okay. Then, so small a and small b, you have that down. Both of these, one spouse now gets the other spouse's half. That's why they're small, because you literally belittled them. Just remember that, like that, even though that's not the case. Okay, so if we step off of that and we understand that those small a's and small b's, that is my orders where I receive half, okay, from the other person. Then the big A is section 45 bis 1 capital A. That actually is now when I said to you before, is how big of me. We each retained our half share. Both the spouses must bring that application. Okay, so you retain your undivided share in the property. Okay, so in that situation, you both bring the application. Okay, again, what am I going to lodge? I'm going to lodge my my court order, or if there's a settlement agreement, or remember, I can apply a redistribution agreement to a settlement agreement in court as well after the fact. Then transfer duty exemption, etc. My consents, again, here's an exception. My consent by the bank is form MM, but because we are after this order, okay, after this occurrence, we now are jointly and severally. Remember, we were in community of property, okay, but now each one of us on our own, our undivided half share. Now each one of us are jointly and severally liable in terms of that that bond. We use form BBB. So on page of your notes, page 177, no 176, right there, bonds BBB. Okay, jointly and severally liable. Simple enough, right? And then that basically, that's your basic applications right there. That's your basic applications right there. Who brings them? In this case, both spouses bring them. It makes sense, right? Whatever you do with your applications for 45(1) specifically, you have to divest the joint estate. Okay, remember that divesting clause at the end? You have to divest the joint estate. There are examples for you on that. We need to get through the applications, etc., that we deal with. Okay, so are you all comfortable with these 45s? And everything that goes with it. Okay, now we go back to our deceased estates notes. Remember, we had the lecture structure and we those diagrams that assist you to study estates and to assess when do I do what. Okay, now your lecture structure for your transfers by endorsements and formal transfers, we're going back to that. Okay, now that's the long page. Okay, I didn't open it on my computer and I don't want to fiddle with this mouse because then I'm going to mute you again. Now we've dealt with the majority of the concepts here. Okay, remember those marriages, the Black Administration Act marriages, the Proclamation 200 of 1987, those spouses were are and were cited as married out of community of property. Okay. On the table, in the table that I summarized for you, the different parties and how you cite them, there is specific mention to this proclamation and the marriages out of community of property. Okay, right. Now, on page 2 of that, the lecture structure that we are talking about, that we're dealing with on the estates, we summarize the important sections for purposes of this. Now, the first and the most important section is section 14. Section 14 of the Deeds Registry Act. One of you asked a question about the Deeds Registry Act. I just want to see if I can quickly get it. About section 14, somebody asked about section 14. I just want to quickly, the sequence of events. I just want to see what that email was, section 14. If anybody can remember that they sent that question, just speak up and tell me what the question was. Diane, it was you now. So Diane, let me just see if I can. Diane, yes, I see here it question. I don't know if I don't think I've got the right one. Oh, right. This is the scenario that Diane asked. She said scenario, deceased, married in community of property, left estate to his wife in the will. Estate consists of immovable property. When the request for transfer was lodged with the deeds office, the wife died. So as you explained, the power of attorney lapses, yada yada fish space, and a new letter of executorship must now be obtained for the estate of the wife. Okay, so now the husband died in community of property, married, and then by the time you lodge, suddenly the wife also dies. Okay, so the question here is, do we need to first pass transfer to the wife's estate and then on to the beneficiaries, the children, or can we skip the transfer of the immovable property to the wife's estate, in effect pretending that she died first and then pass the transfer to the beneficiaries? Okay, now see, the answer lies in section 14. And section 14 only gives us a few exceptions. Okay, a few exceptions. And I just want to quickly get to it. I did have it open until I start paging through my book just now. I've got it marked. So, right. So we always follow the sequence of the relative causes. Okay, and then we have these exceptions. Right. So we follow the sequence of events and sequence of transactions, but, okay, for 14 subsection B subsection 1, you don't have to follow this sequence. If the property has passed in terms of a will through interstate succession from a deceased person to his descendants, and one or the other of the descendants has died a minor. So what is this? This is not the exception. This is not the one that Diane is talking about here. This is because in this situation, interstate succession, the descendants that receives the property has died. One of those interstate is a minor and he has died. That's the situation, right? And is interstate and no executor has been appointed in his estate. Then under those circumstances, you may pass the transfer by the executor into the estate of the deceased person directly, okay, to his heirs up interstatio. Okay, so then we skip all of that sequences. We immediately go and transferred to the interstate successors, descendants. Okay, but look at B small, the subsection B, the first one. This is a very, we don't necessarily come across this a lot, because the first thing that you have to remember with the first exception is that one of the descendants has died a minor. So firstly, there was a death, okay? The property passed in terms of a will or through interstate succession from a deceased person to his descendants, and one of those descendants died a minor, okay, a minor, okay, and no executor has been appointed. He died a minor and he's interstate, and no executor has been appointed. A minor, he died interstate, no executor has been appointed. Then we skip the sequence of events because he would have received the property. Now the first dying, whoever is his interstate successors can pass directly, transfer directly to the successors, the descendants. Okay, so there we skip those. The sequence. Is it your situation, Diane? No, it's not. The next one is, if the registrar is satisfied that the value of the immovable property which has vested in the heir or legatee in terms of a will or through interstate succession would be equal or exceed the costs involved for transfer. I do not know when there will ever be a transfer that is going to cost more than the actual value of the property. So to me, that second exception, it's good to know about it, but in practice, you're never going to get that scenario. Technically speaking, let's say the average property with a selling price of approximately 900,000, your fee is 18,200 or whatever. So what's the chance that the transfer fees are going to exceed the value of the property? Just about never. Well, let's just say never, but you have to know that for the exam. Then 3 is administration of estate, the deceased person, fiduciary, redistribution. Okay, so here we have the fiduciary, including a fiduciary, any redistribution agreement, okay, amongst the heirs and legatees, okay, including your fideicommissory of the deceased or between the heirs. So there's a redistribution agreement, okay, estate, okay. So that's what, this is not your situation. So it's not your exception. So we've ruled that out. Then 4 is, again, a redistribution agreement where we introduce movables not forming part of the estate. Is this your situation? No, it's not. Okay, so there's with number 4, there's equalizing division. So I'm bringing in movables not forming part of the estate in order to equalize. Then 5, again, redistribution agreement, joint estate, spouses, married in community of property, and they've been divorced or separated, and with reference to a redistribution of assets of a partnership on dissolution of the partnership. Okay, it's not your exception. 6, fiduciary interest in the land or in the real right terminates before the transfer of the land or cession of the real right occurs. So that's not happening here. So in other words, my before I can give transfer, the cession of the real right basically terminates. So I can't follow that sequence of events because the right has terminated. So it's about vesting. And then number 7, the right of any person to claim transfer of such land or cession of such right from another person has been vested in a third party, and there's a judgment of court. Again, this is not your exception. So if you look at section 14, then you are going to do firstly a transfer from the spouse to the first dying spouse to the estate of the second spouse, and then you would vest the transfer to the children. Okay, if this was a situation of quo morientes, you guys know what quo morientes is? That is if we die on the same at the same time. Okay, if it is one of those situations, then you would be able to cite the parties, but this is clearly not the case. There is a separation and quite a big time lapse between the first dying and the transfer being able to be executed. You can't mass these states. Okay, so you're going to have in your first in your first transfer, you're going to literally transfer from the first dying's estate to the second's estate, and then from the second to the children. Okay, right. So Daphne, I think, Diane, I think that answers your question. Okay, so that's section 14. Please know section 14 and know how to use it. I have to say though, Diane, is that I think I saw recently, because I had to look at somebody's documents, I'm sure I saw that one of my colleagues actually did exactly that, in that they joined the two estates, not really joined the executor in the one and the executor in the second. It all depends on your situation as well, because let's say, for instance, that first dying spouse, the surviving spouse was the executor. So that complicates things, right? So you may have to get a new letter of executorship for the first first dying, and now you've got to also have the executor appointed in the second dying of them. So it depends on the situation, but I think I've recently looked at somebody's documents that actually joined them. Whether or not it would go through in the deeds office, I doubt it, but then anything's happen. Anything is possible. Right. So everybody feel okay about this? Then we are going to continue on our important sections. Right. On this long document that was sent to you and that you would have printed, the section 21, this is very important. We keep on referring to it. So section 21 of the DRA, marriages in community of property, surviving spouses are joined. So you've got join them with the executor unless one of the 5 exceptions are there. I heard somebody's mic unmuting. Is there something that anybody wants to ask or say? Okay, right, then section 45, we've dealt with that quite extensively. Just always remember that you have a choice here. You have a choice here. Either you can do a formal transfer, or you can do the 45 application to endorse the title deed. Remember, just what I said is the registrar is also a taxing master, so there might be a complaint. People aren't that stupid anymore. They find out all kinds of things. Okay, right. So our next sections is our section 18.3 of the States, the Administration of Estates Act. You know which one that is. Okay. 18.3 is my estates under 250,000 in value. Now, because it's an estate under 250,000, there is no liquidation and distribution account. Okay, so you cannot file or issue a certificate in terms of section 42 subsection 1 that says my account has been advertised, my account has lain for inspection, there has been no objections. It is kind of like a brain dead thing. There's never going to be a section 42 subsection 1 if it's a 18.3 authority, letter of authority. Okay. But if I sell the property or property that forms part of it, then I still have to go to the master and say to the master, here's my power of attorney, endorse it for me. Or here's my section 45 application, endorse it for me at the back. Okay, so I would still do the JM33. This is a sale. Important. 42, subsection 2, sales, not to the air. Okay, 42.1 to the air, but I can't under 18.3s. Does that make sense to everybody? I should get a yes, indeed. Okay, right. Always look at the citations. There is a difference between my appointment in the as executor or my appointment as appointee under 18.3. Irrespective of which one it is. In my power of attorney, I'm going to refer to me being the executor, appointed as such by virtue of a letter of executorship issued by the Master of the High Court, Durban Local Division, on a specific date at Durban. Okay, so I've actually just given you the citation. So that's important, okay? So one has to look at that as opposed to in my deed, I'm not going to refer to the authority. It's just going to be the estate that is dealing with the property. Okay. Draft deed, refer to your executor in the estate only. I've said that already. My draft deed has that. My power of attorney has the authority. And then always remember, divest that joint estate where it's applicable. Vesting, we've said, is, remember, property never vests in the executor with death. It doesn't vest in the executor. As such, it's still the deceased estate. It's the deceased estate that is vested. And then you'll see Regulation 54 of the DRA. Divesting, I divest the estate, I vest the estate, I divest the estate. Okay. Specifically for Diane's example, she would vest that first estate, and then if they are married in community property, which is the situation, divest the joint estate, and then again in the second transfer, vest and divest. Okay, so if we go on, I have a summary on the servitudes, okay, which helps you analyze how do I deal with the servitudes. That's now in terms of section 65 to 69, those personal servitudes, the usufruct, habitatio, etc., the uses and so on. Fideicommissions, remember we have a limitation on fideicommissions, okay, no more than 2, important. And then the facts that needs to be proven, you can read through that. For some reason, in my mind, I'm thinking this sounds familiar. I think I did this before already. So you can just read it again, because from what I'm seeing, I think we've already done this. Those will conditions, marital power, that was abolished. We can't carry that forward. However, we can create certain personal servitudes in the power of attorney and carry them forward in the deed. I don't need it. The general rule is a notarial deed is the way that you create servitudes. However, there's exceptions. There are exceptions, and this is one of the exceptions is the joint estate. If a specific servitude, like a usufruct, is created in favour of the surviving spouse, then I can create it. If it's in my will, I bring that, I create it by quoting the condition in my power of attorney. And also, this is normally also where we get the clause that says any inheritance shall not form part of a joint estate or an accrual claim. So that condition also from the will, I put it in the power of attorney, and I carry it forward to my my holding deed, of my draft deed. Okay. We have nice examples to work through, and there is still enough time. We will work through them as well, and on tomorrow evening as Thursday or Friday evening. Okay, we've dealt with our bonds. We've got to decide what are specifically, are we under 45.1? Are we releasing one of the spouses? But also we have to understand is those properties that are excluded from the joint estate, also how to deal with them, because remember, if they've never fell in the joint estate, then I can't suddenly, because someone died or if a spouse died, suddenly I can't deal with it. It doesn't work like that. So always put that in the back of your mind as well. We've spoken about massing. For some reason, all of this sounds very familiar to me. So I think we spoke about massing. Very important, that presumption against massing. And then causas. I think we've dealt with a couple of the state causas. There's a second voice note on causas that will be uploaded tomorrow. It's just it's too big to do it all in one. Right, so then our checklist, very important here. What we need to look at is section 38 and section 40. Okay, section 38 and section 40, and those are specifically the ones that we dealt with under sundry applications on endorsements, specifically endorsements. Okay, those administration of estates applications, section 38 and section 40. Okay, but we'll revisit them just now, just to continue on your layout. The sale before or after death. In your causas today, I loaded the wording for a sale during his lifetime, during the lifetime of the deceased. Okay, that section 42, subsection 2, irrespective of whether the person sold the property before he died, or whether the executor subsequently sold it, you still need to get that rubber stamp on your power of attorney to pass transfer. Okay, remember 42 subsection 2, that is the sale. It's not the heir that's vested. Okay, so important there. Again, we've dealt with this power of attorney lapses, etc. And then section 45, I think we all want to vomit section 45s now by this time. We keep on coming back to them. Transfer duties, it all depends on whether or not I fall within one of the exemptions, which in all likelihood you will fall under one of the exemptions, unless it's a situation where there's equalization payments coming in. Okay, so that is important to consider under your section 9 exemptions on transfer duty. Okay, right. Sometimes that could be payable. It depends on whether the proprietor is a sole proprietor as such, is also a VAT vendor. They could be VAT payable. Obviously, if you sell prior to, if you sell the asset out of the estate, then it's a fast transfer. You don't have to wait until the end of the administration process. Okay. Then we go on and we discuss interstate succession, redistribution agreements and codicils. Interstate successions, succession, guys, that's section 1 of the Act, Interstate Succession Act. You have to know exactly which section goes with which. Each and every one of those sections could come up in the exam and may form part of your documents that you have to draft, either the power of attorney or even your deed, in which you have to now refer to the interstate succession, whether or not it's a situation that it's a section 1A, A to D are the important ones. Okay, but I did give you a summary of that as well. Then just something that I want to, because I can sit here and read everything off that you already have in front of you, but something that is important, again, I'm going to say Act 70 of 1970. Which act is that? It is the Subdivision of Agricultural Land Act. Okay. If I am married in community of property, okay, again, I can award the property to my wife, or my spouse, or one of the children, for instance. But I can't have it vest. Okay, I can't have it vest in 4 different children, because it comes down to subdivision of agricultural land. There is a very specific part of the Administration of States Act and Act 70 of 1970 that deals with situations where you have you inserted in a will a condition in your absent-mindedness to the effect that, for instance, you bequeath your farm to all your children. Okay, the Act is very clear that it names this situation specifically. What happens if you have a situation like that, or a condition in your will like that? Okay. Your interstate succession always is going to have or will require the next of kin affidavit. Okay, why? Because we need to ascertain our heirs. Okay, so just things that you need to just have a look at. The rest we've already covered. We already covered that. And then on page 6 of the summary again. This is still administration of estates and redistribution agreements. Again, obviously, I'm going to lodge my redistribution agreement. Remember my exception, section 14 exception, with my movables that I bring in as an equalizing consideration. Let's call it a consideration. Okay, section 38 takeovers. Again, if you have a section 38 takeover, obviously you require the consent by the master. This is now for the security of your minor's share. Okay, die kinderbewys. Die kinderbewys. I don't think there's an English word for that either. Obviously, prove in the marriage in community of property, and that obviously you can surmise from the holding deed, your section 42(1) of the 42 subsection 1 of the Administration of Administration of Estates Act. Naturally, I have to deal with this. Why? Because if I have a section 38 takeover, then that would be reflected in my L&D as well. Okay, right. Then my section 40, testamentary trusts, mortis causa trusts. Okay, again, this is something that this is one of those applications that you don't have a choice in. You have to bring this application, and you lodge the will. And you lodge the section 42 subsection 1. It's a mortis causa trust. You've created a mortis causa trust. That trust has the suffix MT, mortis causa trust. Okay, that's why in the notes we say describing the trust. Very important, because that suffix could is very important. Okay. And then obviously transferring the property to a deceased estate. Property must vest in the estate, or in case of a joint estate, the joint estate, never in the executor. We keep on saying that. You never vest the executor. But again, it says the vest in the estate of the person that dies or the joint estate. So again, Diane, I'm going to point this out as this is why you can't use one of the exceptions under section 14. You are going to have to do that little fountain from this side to that side to that side. Okay, right. It's again an hour that's gone by. When we will do a break we'll make it another 10 minutes. So we'll make it until 1938. And then I'm going to do sectional title, and then we're going to finish off on important aspects of the estates, and we'll summarize CRTs just for sake of you being able to prepare. That lecture on CRTs and bonds on Saturday is a huge lecture. You have to prepare in advance. Okay, so yeah, 1938. Is there a reason why everybody's so quiet tonight?
Caffeine shortage.
Okay, but now you can go and have your caffeine fix. I have to say, I literally thought that I wouldn't make it through this lecture up to this point because I am dead tired today. I overestimated my own ability and for this week. Too hard, too long. There's not enough alcohol in the world.
It's been a horrible week.
It has. I haven't lived one like this in a very long time. I literally, my phone starts ringing at 5 o'clock in the morning. By 10 o'clock, I just want to forget that phone even exists. But yeah, let's get coffee.
Yeah.
Manu, horrible is not the word I would use for this week to date.
I have to say. There's a stuff up. They can scrap it from the calendar this week.
Monday evening started 00:48. Tuesday morning was up just after 1. Yesterday morning just after 3. This morning I actually slept late. I only put my laptop on at 3 minutes past 4. And I miss meals, I miss life, I miss days. And guys are screaming, where's this, where's that? This is overdue, that must be done. I'm saying, guys.
Yes.
Welcome to the life of an attorney, isn't it, Marika?
Yes, it is. But it's like I'm sitting here and thinking, I spoke to somebody on Friday. I haven't gotten back to them yet.
And guess what? It's Friday tomorrow.
Yes, exactly. I'm out sitting here thinking, oh my word. Yeah, but let's get coffee.
Let me go put the gas stove on. I'm suffering with load shedding.
Yeah, you guys don't have, yeah, shame. Okay, well, let's get coffee anyway. Okay, so we are back. I think we went a little bit over. Um, okay, I see there's a couple of people that has dropped because of load shedding. Yanni, are you still there? Yanni Botha. It's fine, Zolange. Zamambu, sorry. Yanni? Yanni Botha, are you still there? Okay, I'm going to, yeah, you are there. You just muted. You just. Okay. Finalizing just the last items, which is mainly under sectional title. Sectional title is, as I said to you, it's approximately 2 lectures, full lectures. And at the risk of repeating what will be coming, Yanni, just stay on as long as you can, because I'm going to come back to what you've asked me. So please just stay on. Okay. I know that you probably also have load shedding soon, so yeah. Okay. The sectional title aspects here. What's different with sectional title is just a couple of exceptions where, for instance, Manish, we have our what do you call it, mentor session. So we will discuss if there's any questions. You can always bring it up there. I see that everybody's coming up saying load shedding at 8, load shedding at 8. It's fine. Like I say, as you know, I always recap before I continue on. So we will come back. I won't lose you. I won't lose you. Don't worry. Okay. So the sectional title, the only things that I want to point out at this point is that certain things you can do, certain things you can't do. And what I mean by that is the Sectional Title Act basically sees a unit, which is the section and the undivided share in the common property, okay, as land. Okay, so at the end of the day, it also means that an exclusive use area that is created and registered in terms of the Act, that is also considered to be land. Okay, now the imperative part under estates is to know which acts are capable of being undertaken by the executor at the death of the owner or the developer. Those are the things I want you to make a note. Sectional title doesn't have such a big difference between all the other transfers under the Deeds Registry Act. There's just here and there a couple of things that that are unique concepts under sectional title, and there has been certain decisions that says, for instance, that the executor can't decide that he's going to open a sectional title register while he is administering the estate, or he can't make that decision to open a sectional title register or a scheme for that matter in the course of the administration. So there's a couple of cases that just limits what we can and can't do. One of those things are also specifically any reference to the subdivision of exclusive use areas. Now the first thing here is once we do sectional title, you are going to understand why you can't subdivide an exclusive use area, purely because you can't reimposition an exclusive use area. If you're going to subdivide an exclusive use area, you've got to cancel that exclusive use area and then recreate it. Okay, so that's one of the things is you can't subdivide an exclusive use area, purely because you need to understand what it is, and then when you understand what it is, then you are going to understand why you can't deal with it. The real right of extension as well, there's just a couple of small tweaks there. From what I can see, from what I've heard from Mike, it would look as if though I would be doing some of the sectional title, and if not, then I'll just upload additional information. So from the beginning, I said to you, sectional title is actually so awesome, it's so awesome, so much to do under it, etc. And it is quite a lot of work, but it's a guaranteed 50 marks in the exam. It's really not difficult, as long as you can just wrap your mind around those plans, reading and understanding. Thank you, Xavier. Reading and understanding the plans. Xavier had the nerve to ask me, Marijke, what is an EUA? I'm very sorry that I did that. I've forgotten. We haven't touched on sectional title. An exclusive use area. EUA, an exclusive use area. They are created in two ways. One is by rule, which we all advocate against, and the other is in terms of Section 27 of the STA, Sectional Title Act, and they are depicted on a plan. So they surveyed, etc., and they form part of your sectional diagrams. Literally, I just think about EUAs and I just want to go and open up sectional title plans and show you things on them. So I get very excited about sectional title. And if you do, so we will touch back on that when because it's mostly law that's different for sectional title sectional title matters. But as Xavier quite rightly and when I say he has the nerve, it's because nobody else would have said to me, Marijke, what is an EUA? But Xavier would say, Marijke, what is an EUA? We would have to bench STAs at this point in time, because the Sectional Title Act and sectional titles as a whole, we can't really discuss exceptions to it when we don't even understand what the different aspects of it is. A real right of extension, EUA, the section, the undivided share in the common property, and. Okay, so we're going to bench them basically. And then, as I said to you before, please interstate succession, even on page 7 of the layout, section C, section 2C, so section 2, let me talk slower. The Wills Act is important, section 2, capital C, subsection 1 and subsection 2, section capital D, okay, Interstate Succession Act, specifically section 1, subsection 6 and 7. Those things you have to study and learn and understand. And there I also have to say is you have to understand the difference between an heir and a legatee, okay, because that is pivotal in conveyancing, especially in that situation that Diane gave with the death and the death and the death. The Wills Act is section 2, section 2, subsection 1 and subsection 2. So section 2, subsection 1 and subsection 2 and then that's section 2C, capital C, subsection 1 and 2, and then section D under section C 2. Okay, right. So they are summarized for you. You guys have seen what my notes look like, so I obviously also just summarize those for you. Okay, so what I want us to quickly stand still. I was busy talking about. Sorry about this. I was busy talking about that death and the death and the death, and the estate. And why that's important is the representation per stirphuis. Okay, those of you who don't know, the representation by per stirphuis is basically if I'm an interstate heir, then at the end of the day, if I fall away or I die, then my descendants will be able to represent. Okay. I'm not quite sure. I just see something about, do you see the deceased, etc., the spouse, etc. Guys, as I said, there is for everything there is a summary on the Wills Act, etc., that will assist you. As you can see, just in one night we do administration of states and all of these different legislation. So always remember that that we have to go a bit faster on legislation, where we're not actually using an example to prepare for drafting. Okay. Now, I want to step off of this and quickly, and I'm not going to hold you guys too long. I just want to quickly talk to you about certificates of registered title. We still have enough work to do, quite enough work, quite honestly, more than enough work in actual fact, in the coming days, etc., and a lot of drafting that goes with that. So please visit eLeader frequently. Okay, right. Now I want to talk to you about the CRTs. There's only 10 of them. I'm just going to summarize for you, and I'm going to post this to you. Okay, so there's only 10 important ones. Now again, you have to bring an application, and then you have to issue this specific form. Okay, which is now the certificate of registered title. It comes normally in a form. Okay, it does, because just like a title deed, it has a specific format. What is a title deed? The title deed is my normal form E, my form F, my form G, my form H. Okay, of the Deeds Registry Act. Okay, so now if I want to issue a substitutive title, then I have to bring an application to the registrar, and I prepare separately my form, and then I lodge that, and then that is issued. And as I said to you before, a certificate of registered title basically goes and stand in the place of the title deed. Now, this is just a quick summary of this. Now, your CRTs start from section 34, section 34, and they continue on up to, I think it's section 44 still has section 43, section 44 as well. Okay, so why am I telling you this? Firstly, your application, okay, no form to it. So you would be able to easily make up marks there, because you draft. What is an application? Prep clause, heading, and then you are the owner and you are applying for a specific certificate of registered title. The form, the prescribed form, on the other hand, because it's a title, a substitutive title, nonetheless, I have to have my prep clause, then halfway down the page, and then I have my certificate. So it's going to look exactly like a deed. When you draft it in the exam, it looks exactly like a deed, because that certificate can also may be endorsed on that area that is between the heading and the prep clause. So if we start and we say, right, section 34, subsection 1, this is the certificate of registered title of a joint owner. A joint owner's undivided share. A joint owner's undivided share in land. Okay, so that's section 34, subsection 1. It has a prep clause. Okay, it has a prep clause, it has a heading, and that heading refers to section 37. Okay, because section 37 is basically your empowering section. I always refer to them as an empowering section, because that's the one that basically says issue a certificate of registered title. So my heading is section 37. My application for the joint owners certificate of registered title is then in terms of section 34, subsection 1. So in my CASA, I'm going to say the registrar of deeds issue a certificate in terms of section 34 to me as a joint owner. This is just quick abbreviations. Okay, so half share, for instance, if I hold a half share interest in and to IRF 101, Mans and Toti, then I would apply in terms of section 34, subsection 1, okay, for a certificate of registered title. Why would I do this? I do this if I want to encumber or transfer a fraction of my interest, etc., etc. So there's only a couple of situations where I will use this specific section, but it's the joint owners. And why is this important as well? Is because it's Form I. So I bring my application, I use Form I, but it's my certificate, my CRT is 34, the joint owners certificate of registered title. Okay. Now, interestingly enough, the first couple of CRTs are all either Form I or Form J. So ICA and J, né? So I and J, that's the majority of my first couple of applications. So joint owner, section 34, subsection 1, Form I is my certificate that I prepare. My application is under the heading of section 37. Okay, 37. Right. Joint owner. Okay, so I bring that as such. Then my second certificate of registered title that I can take out that also uses Form I is the section 35 CRT, section 35. So Form I is in for section 34, subsection 1, joint owners, CRT. Then again, Form I, section 35. This is the aggregate shares. Aggregate, listen to this, aggregate shares. So if I say aggregate, it means that I have more than one share in different properties, for instance. Okay, so that's Form I. I'm telling you this now so that you can just identify for the moment that I have a specific form, which is Form I, for only these CRTs. Okay, and that is, as I said to you before, it's section 34, subsection 1, joint owner. Section 35, aggregate share. Aggregate share. Okay, right? The fraction of my share as joint ownership. That falls again under section 34, but this is subsection 1 capital A. This is just a quick summary of the CRT, so don't freak out. This is also an application in terms of Form I. Then you have the CRT, as I said, the aggregate share. The aggregate in property, so my share in properties, look at section 35 and 34.1, as I said, Form I. These are all Form I. Now, the next couple of CRTs, they have their own forms. So only these ones use Form I. So it's 34, 1 capital A, 35 aggregate, and then 34.1, okay, the CRT form section 36, okay, 36, okay. Remember, all of these, they are joint shares and properties, etc. You will know it the moment that you see them. The ones that fall under Form J, the first one is section 34, subsection 2, okay, and this is again, it's a different form of application for again a joint ownership, but your title deed is again lost or destroyed, but it's in this situation it's the joint owners. Okay, the joint owners are applying to the Registrar of Deed. They have lost their copy of the title deed. It's not the deeds registry's copy. It is the owners. Okay, it's the owners. Section 34, subsection 2, joint owners. Okay, right. And as I said, Regulation 68, we follow the same format with the affidavits, and that's Form J. Form J. Now, there's a CRT in terms of section 39. This is where there's a mistake in my title deed, and now I'm fixing the mistake. Okay, so that mistake in my title deed, Form M, mistake. I'm correcting a mistake. You use Form M. My consolidated title, Form O, section 40. Now I'm consolidating two properties into one property. That's why it's Form O. It's like a fat one. Okay, it's a circle, Form O. You'll remember it like that. Then my subdivisions, section 43. Okay, we've spoken about that before, and that is Form R. Subdivisions, Form R. Okay, and then there's a certificate for land that were previously held under sectional title, and that is Form SS. Okay, sectional title SS. That's a CRT for land that was formerly held under sectional title. Remember, I said to you there's 3 registries in the deeds office right at the beginning. This is where it becomes important, because I've got my township, then I've got my agricultural land, and then I have a sectional title. So if the land was previously held under sectional title, that is why I need a CRT Form SS, because it was formerly in a different registry, formerly held under sectional title registry. Now, obviously, I'm taking it back maybe to my township or my agricultural land, Form SS. Again, before you even go and put your head down tonight, you're going to get a summary of this already by email, etc. The one I want to stand still at is section 38. Okay, section 38. Now, Jani had that question that she posed, where again I'm just going to read it because this thing has been bugging me for, I think I read too fast here. Her question was, Regulation 68, both the client and the deeds office copy of the bond is lost or destroyed, and it is not the intention for the parties to cancel the bond. So they just want to replace their title, their deed, their bond deed, okay, their mortgage bond deed. They don't want to cancel it, okay. Now, again, their copy is lost and the deeds office copy is lost. Regulation 38 is there for those situations where both the deeds office and the owner's copies have been lost or destroyed. Now, see that separate from the application that I just, or the CRT that I just referred you to earlier. I have a question. Yes, Xavier.
Regulation 38. Isn't it
section? Did I say again regulation? It's section.
Yeah.
Section. I'm sorry. Look, I have to say is I keep on doing that. Once it's been pointed out to me once, now I fixate on it, and now I keep on messing up. It's section 38, section, for Pete's sake, section 38, regulation 68. Okay. So regulation 68 is my deeds that have been lost, but only the owners have lost them. Okay. So we bring that application by way of an affidavit. Now, I also, earlier in this last 15 minutes, I spoke to you about the joint owners. All of the joint owners lost their deed, not the deeds office. All of the joint owners lost their deed. Then they bring an application and they can issue a certificate of registered title. Okay, they can issue a certificate of registered title that will replace the deed. Okay, I've referred you to the form that is important there. But again, that is different to this this section, section 38. Section 38 is different because here it's not the owners, it's the deeds office copy as well that's lost. So in other words, as opposed to regulation 68, where we say only the owners, they've lost it. But section 38 says owners and deeds office lost it, okay? And then when I have more than one owner, multiple owners, and we've lost our deed, under those circumstances, we can also apply for a CRT as per my notes on the abbreviated CRTs, just for your own introduction to CRTs. Okay, so differences there. Now, what and by the way, the form under section 38, okay, is form L for lost. Okay, so section 38 that has the deeds office and the owners lost their deeds. The form, my application is in terms of section 38. My form is section L. Okay, right. Now, I've said to you before, I can compile my my deed, okay, from going back to my what do you call it, my flyleaf, that basically told me which conditions were inserted in the deeds based on the township that was created, etc. Not only can I do that if it is possible, but what I have to do under section 38 is I have to lodge my diagram. I have to lodge a diagram. Now, this is where, again, everything that we do in conveyancing centers around that extending clause. Remember last lecture we did extending clauses, and I said to you form TT or form UU, as will appear from diagram D, diagram SG number, whatever, held by deed of transfer. Okay, so as will appear when I first create my land, and then if it's already been created or subdivided, whatever the situation is, then I use my form UU, which is first transferred and still held. Okay, so why am I saying this to you? It is so that you can understand that my extending clause that refers, and it will always refer to a deed and a diagram or a general plan. That is where we find the history of our property. Extending clauses are there specifically to assist us to find the history of our property. So with a section 38 application for the Form L lost deed, okay, I would lodge my diagram with it, and that would assist the registrar in identifying this property, and then and its content, and that is how we track the conditions as well. Okay. Now, Yanni's specific situation refers to the mortgage bond. Okay. Now, I have to say that I can replace or have a certificate of registered title issued in respect of any deed, okay, in the deeds office. But this is a mortgage bond. So right at the beginning of this evening, I think we all were tired, or at least I was tired, etc. And I kept on missing the fact that this is a mortgage bond. This is a mortgage bond. Okay. So I can't use section 38. Okay. This question has gone to conference time and time again. There is only one way I can ever replace a deed, of a mortgage bond deed. Okay, there's only one way, and that is and this is now purely for the situations where the deed has been, when I say deed, the mortgage bond has been lost in the deeds office. So we can't go and microfilm it or get a copy of it because it's gone. The deeds office doesn't have it. The owners, the holders of the mortgage bond don't have them either. Okay, it's gone. It doesn't exist. Okay, it exists, but nobody has a record of it. So now, and this is why this keeps on going back to conference, because everybody has tried to use section 38. But it's not possible to use section 38. You can't use section 38. And you can't use it because not only does the section only allow for a deed that can have a diagram attached to it in its application. So it is only land. Okay, it's only land. And that title deed, the title deed, the deed of transfer, is the only thing that I can use to under the application under section 38. For the mortgage bond, which basically has what? It has in it security in respect of a debt. Okay, so there's money that you have to pay back, mortgage bond. Okay. So if I have to replace that one when the deeds office and everyone else has lost it, there's two ways to do it. Either you cancel the bond, okay? If you cancel it, obviously you bring your application for cancellation and there must be a consent. And now, here's the problem. Here's the problem. Now, normally I would lodge my bond in order to have it endorsed. But now I can't do that in this situation, and that's why the applicable regulation, which is regulation 68, not section 38, refers to an advertisement for 6 weeks, as well as an application, and then an advertisement for that has to run for 6 weeks, okay, before you can issue an endorsement or an application for purposes of replacement. Now, in terms of this regulation, Regulation 68, subsection 11, okay, in terms of that, it only allows you to either cancel or it allows you to have it replaced, but there's risk in it. What if the parties can't remember what's in the deed? Now remember, there's nobody has a copy of that mortgage bond as a deed, okay? And the deeds office doesn't have either. So who's going to tell us what has to be in that mortgage deed, that mortgage bond? The parties would have to, one way or the other, decide what was in it, because nobody can prove it, right? So if this is the case, this is why it allows for the court to be approached. But no, affidavit won't fix it, because the registrar conference rulings has been that either you get a court order saying what that bond is and to replace it, but you have to either do that or you have to cancel that bond. You have to cancel it and register a brand new one. Okay. But there's risk to that. I can't do that. What if the person is at risk of going insolvent at this point in time, and now I want to find the terms of my mortgage bond? So that is the crisis relating to that. So the solution by conference was, it's going to cost you a lot of money. Bringing that application is about 30 to 50,000 rand in the deed, in the High Court, because the only court that can deal with this is the High Court. Okay, so the conference ruled on that specific matter that cancel the bond and register a new one. Okay, and purely for that reason, because going to court might be too costly. But I cannot use Section 38. So I think at the beginning I said something completely different and just fixated on the fact that the document is lost by the deeds office and by the owners. But Yanni, does what in your scenario? I think it's a personal scenario. Maybe you're dealing with it in your own office. Does that make sense to you now?
Yes, thank you so much. I was, you'll see in your comment, I was actually putting together an argument because I think we were both not on the same page, but now that you've gone back, yes, that my biggest thing was, obviously, I haven't dealt with an instance where we've got a court application, and I just wanted to know from your experience, which one would be the most cost effective? Obviously, going to court is extremely expensive. But if it's an option available to your clients, I mean, you've got to put it on the table and explain it.
Yes, but you have to remember that that could be 6 months away, and it could be 30 to 50,000 rand. If your client is in money, yes, go for it. But otherwise, it's a cancellation and re-registration, and purely re-registration because nobody knows what was in that document. That's why. And it's funny, I've explained this previously, specifically with reference to the CRTs 38 and Regulation 68 and the differences to that. And also what happens if my joint owners have lost it and their CRT. And I've looked into everything about it, and it has gone to registrar, to conference a number of occasions already, and they keep coming back and say, everybody tries 38, but you can't use it. Cancel it and re-register it. Yes, there's risk in it because recreating the debt. There could be, the insolvency, all those kinds of things. But your alternative is go to High Court and get an order. And again, you would have to be pretty darn sure what you want to put in there, in that application. So that's a very long-winded explanation, eh? But
no, thank you so much.
but something was just keep on bothering me about that, and then I realized, hello, what troll have I just spoken to you about? I was so busy distinguishing between Section 38, both people and the deeds office lost their deed, but it only refers to my deed if it's lost, not my bond, my mortgage deed. And I think that's important. My mortgage bond is also a deed. It's a mortgage bond deed. Okay, so it's my proof that I have a mortgage bond over it. Okay, because that's my proof, my title, not really my title, but my entitlement to recover.
Sorry, Marika, also just to interrupt you. What I liked was you raised something that I didn't actually think about at all, was the fact that for Section 38, you've got to attach that diagram.
Yes.
That diagram, it kind of hinges. So important. Yes. Thank you.
Yes. I don't know why I had a moment there, because I always, when explaining CRTs and specifically 38s, I always refer to the diagram and the conditions of establishment. But I was on my horse and I was heading for the sunset. So I hope that clarifies. Anyone else that followed that argument, or not argument, that explanation and the question that Yanni had? Are we almost on the same page? I'm waiting for Xavier. Yes, Xavier.
Now that you've explained it, Marika, thank you. It's actually been quite simple. The actual title deed or the holding deed or whatever, the actual deed of transfer, that's not lost. The bond's lost.
Yeah.
So, yeah, it's part of the pack that gets submitted. It's just that one little thingy that's missed. And in the actual holding deed, or when you do your draft, and that one is then stamped, and there is a stamp that says there is now a mortgage bond. Number one, you can recreate your facts from the mortgage bond with regards to original capital on there. The banks will have a history of when the account was open, what the installments were, what the interest rates were, and then to actually recalculate the capital will not be that difficult, because remember, the original bond is still there. The original deed is still there. It's just the bond that's no longer there.
Okay, but now we don't have a bank here, and we don't have a bank that has a history of 100 years. Now we have two persons, and it's a person that granted an extension of credit and required a bond over the property as security. Now, how do we recreate the terms of that repayment? What if the repayment was supposed to be in 10 years? We don't have proof of it, because once we stamp on the deed that there's a bond, we don't say the bond is for this amount, but also the percentage of interest, and also how long will you pay it back. So none of that is there, and that is the problem, because who of us, if it's a bond and maybe 30 years repayment was maybe the agreement, how would someone remember after 20 years exactly what was the terms and how it would be dealt with? Because remember, there's no form. This is the other thing, is there's no prescribed form for an ordinary bond. So I can draft it in any way that I want to. There's just a couple of things that I always have to carry forward. Property description, parties, and then there's a couple of things regarding ranking and so on that has to be in there. But there's no form that says this is what a bond must look like.
No, 100%. And that's why the minute the people don't agree, hopefully they have big pockets, because they're going to have to go to the court. And then the court will decide from the evidence, based on the circumstances of each and every single case, what was the most reasonable probability to be the terms and conditions of that bond, and then that will be the new substituted bond.
Yeah, but now the option is not just court. The alternative is, if we can agree, then we'll just cancel it and we'll re-register a brand new bond. Hopefully everybody agrees on what everyone wants to achieve with it.
Indeed, and then just it's not as if the mortgagee can then all of a sudden say, okay, fine, there's no more bond, I'm going to stop paying. He's created a history of installments. I mean, there's probably a debit order that goes off. So the liability still exists. Now, if there's no written document, what then applies? Isn't there something called the common law? So the minute the debtor gets nasty and starts denying the existence of the bond and the facts actually prove to the contrary, the creditor can turn around and say, listen, according to our books, you still owe us 51,000 Rand cash up front, cash payable now. And then common law kicks in. So a debtor will be exceptionally stupid to deny the existence of a contract because that actually protects him.
Yeah. But you do find these situations, and Manish asked the question is now, how can you lose it? You trust me, if it's a bank, they lose it in their securities. And the problem is, you all are going to remember this conversation. If it's the bank that lost the deed or the mortgage bond, they take up to a month, 2 months to instruct an attorney to say, okay, bring an application to replace it. Because they don't want to pay that 3,000-4,000 Rand. They just don't want to pay it. So that could literally delay your transaction with 2-3 months at a time. They take the best of time to instruct to replace the deeds or bonds, and it's very frustrating. So, Yanni, really a great question. Thank you, and I hope that everybody could at least find something in tonight's lecture that assisted them and helped them, even though we're all tired and worse for wear after this week. Really, guys, you can see here I take out your questions and we discuss it and we deal with it. So please do use, I invite you, if you want to discuss something, call me, book a Zoom, or send me an email. I will come back to you and I will help you. Okay. Thank you. I think Xavier has way too much energy. And he's like a pep rally person. So we all have to just keep going. We've just got to soldier on. It's almost, well, it's not even almost over. Just this week is almost over. But it's hectic. I know it's hectic. I know. And it's the first time they gave us a whole week of lectures. But I'll definitely not underestimate or overestimate my stamina in the future, because by Thursday I'm done after this week. So, but thank you everybody. I really appreciate your interaction, and as I said, there will be Salusa 45. Okay, we used to drink it at Varsity. It used to keep us up for a day or so. But yeah, I am uploading. Please give me back feedback on what you find on eLeader, and ask me if there's additional information that you require that I will upload for you there. Thank you, everybody. Have a great evening further. And yes, let's go and drink something to give us pep. Good night, everybody. I hope you have a good evening. Thanks. Signing off.
Bye.